Thank you very much, Devanshu, for the opportunity to participate in this panel with this panel of esteemed experts. Now, the theme of this panel is reform, and we have 4 topics that we want to look at in our panel discussion. The first is pre-packs, which is good because we've already had a number of mentions of these today. The second is groups. The third is personal guarantees, and the fourth is cross-border insolvency. The format we want to adopt for this panel session is there'll be an introductory set of comments from one panellist, followed by a brief response from another panellist, and then we want to go straight to you, the audience, for your thoughts on that particular topic before we go on to the next topic, because we're very aware that there are many experts sitting in the audience. So we would really like to hear your views on the optimal way to go forward with reform in each of these 4 areas. Okay, so the first area I mentioned we're going to look at is pre-packs. Mr. Sinha is going to open with comments on this topic, and he'll be followed by responses from Mr. Khare. So over to you, Mr. Sinha.
Thank you. Good afternoon, everyone. I think, as you mentioned, that pre-pack was just, in fact, discussed in the panel before, so it's a nice segue to sort of discuss it, further. And basically, as I also want to, in the one of the previous panels, the word ICU was referred, and I want to actually use that because it created interest. As I sort of think about it, that look, the initial few cases which were referred to, an IBC and resolution happened, were perhaps either in ICU or threatening to get into ICU. And therefore we are now, I think, in the cusp of looking at what can be the future. And therefore, I think this, with the law being, very well settled, thanks to very swift action of both our judiciary and our legislatures as the Bankruptcy Board, we have pretty much have, all aspects of the bankruptcy code, settled now. So with that, I think we are now perhaps getting into a right time to discuss pre-pack and looking at how we can get in more investment. I guess since it was already discussed what pre-packs are, pre-packs have been prevalent in your country and been used in UK in some sense. So fundamentally, what it does, it tries to and preserve the value, the enterprise value of the enterprise, and it tries to sort of strike a balance, between the interests of various stakeholders, the creditors, the debtor company, the other stakeholders in the cast of characters. So typically a pre-pack could be perhaps initiated in 2 forms. If a company is not already in default, but there is a suspected stress which the promoters feel, it could perhaps, classically in the banking parlance, even if default has not been triggered or there is not threatened to be triggered, it could be then initiated by the debtor itself, the promoter itself, or in the event that there is a imminent event of default which is happening or has already happened, then the creditors can initiate a pre-pack conversation. In fact, as I sort of think about it, there are sort of 3 things I would like to call out as perhaps issues in the Indian context or any context one has to deliberate on. One would be with respect to transparency. How do you create enough transparency in the process? Because sometimes pre-packs are criticized on the fact that there isn't enough transparency in the process. It goes on behind closed doors of a promoter who's otherwise not been able to run the company well, and therefore that's one. The second is, how do you ensure that there is, in our context, you give the company back to the same person. So we have this section in our code, which is called the section 29A, and the section 29A was the one which actually made it us versus them insofar as the resolution process is concerned between the creditors and the existing management. So how do you sort of resolve that kind of stress? And then the third would be, how do you bring in cooperation? How do you bring, as someone mentioned in our previous panel, that trust is sometimes an issue insofar as when we are dealing. So how do you then deal with this whole question of cooperation, and whether it is a cooperation between lenders or predominantly between lenders? I would sort of think that these are the three aspects one needs to deliberate on when you're sort of looking at and thinking of a conversation on pre-pack. And I have a magic solution. And I think some of the things, since we were talking about how we should be, really talking on this panel about what we should be doing and what the law should look like, I think, if we were to sort of just confine our conversation with respect to a situation where we think that event of default is already triggered, and therefore now the creditors need to initiate a pre-pack. So let's take that example. Our law already has circular which has been issued by the Reserve Bank of India, which is famously called the June 7 circular, which most people will be familiar with. This June 7 circular really says that, so I just think that what we perhaps need to think about is to look at a regime like the June 7 circular and merge that with the provisions of IBC. And what I mean is that June 7 circular says that the lenders need to huddle in a room and spend within a month decide whether or not this company, which is in stress, deserves a resolution plan, and therefore if it deserves, if it's resolved or it's decided that yes, this is a company which indeed is fit for a resolution plan, then all the lenders sign an agreement, an inter-creditor agreement, where they agree to behave in a certain manner. And I think, to me, this is where perhaps a pre-pack kind of solution works, that the lenders work, given that, again, I'm assuming that this is a company where lenders have decided and have come to a decision that this is worth resolving and working with the existing promoters to resolve the company. It is therefore going to have maximum value, as Kaushik was mentioning in the discussion a little while ago, that the lenders or the resolution applicant or whoever is buying or investing in the company would have the comfort of getting appropriate reps and warranties. The directors would cooperate to be able to give enough information for appropriate price realization. So you do all of that, and then you enter into a resolution plan, and immediately after you enter into a resolution plan, agree to do a resolution, you appoint an insolvency professional. The insolvency professional then sort of really, and that's the stage where we sort of deal with first the cooperation, and then we deal with the issue of trust, where we are looking at the promoters, getting the moratorium, the interim moratorium, operating while this whole the insolvency professional looks at and evaluates, collects claims, and does all the stuff which is required, does a price realization discussion and process, and thereafter, if it's it comes to a sort of a decision that yes, it is worth, then even our law also has this concept of an oversight committee. So therefore, again, to sort of look at whether we are giving back, and the whole conversation of giving the company back to the promoter and him getting it back at a lesser price, you have a committee which is an oversight committee, overseeing committee, which is a committee of independent, eminent personnel who look at it and say yes, they believe it's worth it, and thereafter you file for the resolution plan with the bankruptcy board, and the rest of it is the standard process which will take over. So to me, I think this would deal with the process of at least the three things which I have in mind.
Thank you so much, Mr. Sinha. A response from Mr. Khare.
So thanks, Nilanjan. You've sort of summed up the issues around pre-packs very well. Maybe what I'll do is I'll just add also a little bit of practical experience to just add to what Nilanjan has mentioned. So you mentioned the three sort of key items on transparency in the process, giving the company back to the same promoter, and cooperation with the promoter. And that's kind of hitting the nail on the head in terms of how we could go about pre-packs. Now, the June 7 circular in that sense is a useful, we could in a way call it a useful experiment in pre-packs. Although there are some aspects of the June 7 circular which don't quite, translate that well, which I'll come to. Now, the fundamental disconnect, of course, is that once we go under IBC, Section 29A will prevent a lot of existing management from actually putting in the resolution plan. On the other hand, before IBC, and we've had this experience in restructurings under June 7, there is actually no incentive for the existing management to cooperate in a fair and transparent process. So essentially you have a situation where effectively if you want to run a proper market process, do a proper price discovery, find the best applicant for your restructuring, that's something which is currently very difficult to get existing management to agree to, both in terms of showing information. Of course, they themselves might be a interested bidder. So you have a situation where you have potentially huge information asymmetry, where the current management may also want to put in a resolution plan. So I think that's one practical problem which restructurings under June 7th are facing. My sort of solution or suggestion in that regard is, once a company goes under IBC, obviously it comes under the resolution professional, but often you have cases of non-cooperation by the existing management, and the IBC does provide for that. So you can sort of file an application under Section 19 and seek sort of cooperation of the promoters. So potentially, if a similar concept could be extended to pre-pack restructurings prior to a company going under IBC, I think that's something that would probably go a long way towards actually facilitating a sort of good and clean and robust process before even pre-IBC. The second thing is, I think now actually, so here's the other reason why I think possibly we need to actually extend provisions of the IBC in some extent to the pre-pack restructuring process, if we were to introduce it, and that is that actually the RBI only has jurisdiction over sort of Indian banks and financial institutions. So even today, if you take the June 7th process, you could well have a situation where about 70% of the debt is required to act in accordance with the RBI circular. So only about 70% of the debt has to sign the ICA, etc. So when you have sort of individual bondholders, or you have foreign creditors who don't have to take part in the process as such, that in itself sort of really reduces the effectiveness of those prior restructurings. So I think the other possible way to deal with that is to also introduce potentially the concept of a pre-pack within the IBC framework, and possibly provide for the requisite majorities within a law itself, as opposed to only the RBI sort of circular which has limited applicability. So I think in the interest of time, I'll sort of stop there and maybe we can.
Thank you. Questions from the audience or comments from the audience on pre-packs and any need for reform in this area? Yes, there's a question there. Thank you.
It's not a question per se, but pre-packs, if my understanding is correct, requires an RP or an insolvency professional to administer the plan or to execute the plan once it's approved by the NCLT. So in the current scenario, do we think that insolvency professionals in India are capable enough of implementing the plan or coming out with a turnaround strategy for the company, or will it take some time to develop those capabilities so that insolvency professionals can actually go ahead and implement a plan?
So from what I understand, the way the RP is supposed to function is that they're supposed to carry out the marketing exercise. I think the concern you've raised is valid. There are a lot of concerns over whether an RP can carry out a marketing exercise in a sufficiently good manner in the Indian context. Even where you have a more developed system of IPs, say for instance in the UK, there is a concern that simply because the pre-pack is not a court administered or a very public process, the public marketing exercise is not good, even when the RPs themselves may be capable. So in that sense, I actually am a skeptic about the pre-pack mechanism, because I really wonder what are the firms that will actually benefit from not having an adequately public marketing exercise. Why do we not want to have the cost of a court process? I think that this will only make sense when there are smaller companies where you know that there really isn't a market to acquire these companies, and when you know that there are very limited players, so you think that the RP can A, conduct that exercise, and two, you know that the cost of a public marketing exercise may not be justified. And sort of just going beyond that question, I have one more comment to make. I think to me, while I see the rationale of why we want to pre-pack in India, I think there is one really important thing we should all possibly think of. When we talk about the speed of pre-packs, when we talk about pre-packs, we always talk about the speed of pre-packs. We'll have a very quick resolution. But one of the major sources of delay is really the time taken in litigation. And unfortunately, the way I see any kind of pre-pack panning out in the Indian context, you will need an NCLT approval for it to really be binding. And I don't see the time at the stage of the NCLT itself going down. Further, so sorry on that. Further, we also talk about the low cost of a pre-pack, right? But we're still talking about creditors negotiating. So in that case, then how are we really different from the COC mechanism? The only thing that you're doing it is that you're doing it before the IBC starts and not after, just like Kristin said in our opening speech. So I think for me, I don't think that pre-packs can really work in the existing scenario without significant amendments being made to what we think of as a resolution mechanism for India. And we'll have to, if we have to bring in a pre-pack kind of scheme in India, we'll have to envisage a very different kind of CIRP in my view.
Would either of you like to respond to that, Mr. Khare?
Yeah, sure. I think, see, if you take the concept of a pre-pack, essentially it's that, well, a restructuring outside of court doesn't provide the legal sanctity that you need for a resolution, a proper resolution. And the IBC, or any statute worldwide for that matter, provides that you can do things like extinguish debt, extinguish security, by once approved by a statutory majority. I think, so I mean, the way it should work, or if you take the ideal sort of pre-pack mechanism, is all the creditors sort of sit together beforehand, agree, run the process, find an applicant, find the best structure, then just admit it into the IBC, get it approved, because you've got all your approvals in place, get it approved, get the NCLT order, which will provide the statutory effect of whatever that proposed restructuring is, whether it be transfer of assets, extinguishment of debt, etc. And then and then you move on with life. So I don't think it's unachievable. I agree with Shreya's point that I think cost does become an issue, when we're doing it. But I think that's the case for lender and restructuring processes anyway. So even prior to the IBC, when you had your sort of S4A mechanisms, even today under the June 7th, lenders will still typically appoint a process advisor. There will be a lender's counsel, there will be someone to analyze everything. So I think in that sense, you look at it in the ideal way. If you've done it once beforehand, you found your ideal thing, you maybe don't need to do it again during the CIRP process. So, but yeah, I think, without, my sort of main reasons why I think currently it's difficult to implement is one, of course, the 29A angle in IBC, and and the fact that actually don't today have anything requiring all creditors of all classes to sort of agree on something beforehand. So it's entirely voluntary, and it doesn't always work that way.
Thank you. I might just abuse my position as chair by offering 2 comments myself. In response to Shreya's observation. So the question from Shreya was, why do we want a pre-pack? What are we asking this to do? Why do we need this? And I can think of at least 2 possible answers. One is the answer Shreya alluded to, which is that some companies will be so small, or the nature of their assets is such that they cannot survive for very long in a trading resolution process. Either they're too small or their assets are mostly human capital, and there's just no way for those companies to survive and trade in a long, prolonged resolution process. And so for these companies, the only real buyer, the person who places the highest value on the business, is likely, as you suggested, to be the controller, the shareholder manager. And in fact, many UK pre-packs are sales to shareholder managers. So they are connected party sales where the person acquiring the business is the shareholder manager. And so then the question comes, how do you ensure a proper price? So Shreya's concern was, how do you ensure that this sale is not at an undervalue? And there are 2 ways to protect unsecured creditors. One is you can say, well, you can't do anything without getting their prior approval. And that will mean they have more say, there's more transparency, but it will also mean the going concern value probably won't survive because you have to announce this publicly. The other way to protect unsecured creditors is by ex post disclosure. So you don't ask for prior permission, but you have rules that very strictly regulate how much unsecured creditors get by way of information afterwards. And you require the insolvency professional to justify their choice of a prepackaged sale and their marketing efforts. And English law did not do such a great job of this historically, but it does a better job of it now, thanks to the intervention of regulators. The other reason you might want to use a pre-pack is because the company is large enough to be sold or to be reorganised in a public process, but you think that the longer that process goes on, the more the indirect costs associated with publicly announcing the distress, the worry that customers and suppliers will go. And so you might want to use a pre-packaged process to try to truncate the period of time the company spends in resolution. But for this to work, I think you'd need to have 2 things which I don't think are necessarily obvious on the current state of Indian law. One is, I think you'd have to be able to bind yourself to only vote on one plan. So you'd have to validly bind yourself to not vote on a rival plan later. And then the second thing is you'd have to have a way to stop the process being scuppered by the introduction of lots of rival resolution applicants later down the path. And I think that's tricky on the current state of the law. But now I've abused my position. We must go to topic 2, groups, and Shreya is going to take the lead on this topic. Thank you, Shreya.
Thank you, Kristin. So I think the basic, the essential conflict in group insolvency is how do we recognize the economic reality of corporate groups in a legal framework which typically recognizes companies as separate legal persons and believes in their asset partitioning. Now, the very first question that comes up in group insolvency is, do we need a group insolvency regime? Now, on one hand, there are proponents of group insolvency who argue that the goal of insolvency law, which is maximization of the company's assets, is only going to be realized if you're going to look at the various interlinkages that may exist in a group. Say, for instance, a case like Amtech, where each of the associate companies were structured so that together they were forming a value chain. So just buying one associate wouldn't actually give you an asset that would have as much value as if you bought all these associates together who were forming a value chain. Or say another company where all the creditors have dealt with the entire group, thinking of it as a single economic entity. So wouldn't it then actually help you price your credit lower in the ex ante when you know that the way you dealt with the group ex ante is actually going to get recognized in insolvency law ex post? There are also people who disagree with this belief and say that typically creditors only take into account the assets and liabilities of a specific company, and to the extent that you have a group insolvency regime that takes into account interlinkages that are beyond this, we're imposing costs of monitoring on these creditors, and this is going to result in an ex-ante increase of capital. And sometimes people also feel that a group insolvency regime is going to actually cost a lot more than what it's going to save you in terms of value maximization. The IBC itself doesn't really have provisions for group insolvency. Notwithstanding this, we've seen courts in India have actually gone ahead and introduced a group insolvency framework. And I think Videocon is a perfect example of that. In this one case, we've seen that the NCLAT ordered procedural coordination, which is that the proceedings of different subsidiaries of the Videocon group were coordinated in one NCLT bench with the appointment of a single insolvency professional, and then substantively consolidated the assets of these group companies, which effectively means that all the assets as well as the liabilities of the group company were pooled, and it was treated as though all these different companies were one. Now, I think this is something that should be debated, what are the situations in which one or two of these approaches needs to be taken, whether the NCLT itself has a jurisdiction to order any of these things under the current law, and where it does choose to do it, what are the factors that should keep it in mind to ensure that it's not doing it bluntly, that it is taking into account all the reasons why somebody chose to actually incorporate as a group, as opposed to in a single entity. Why did I choose to have multiple subsidiaries? What will happen post the reorganization, where you've now told me that my SPV is supposed to be treated just the same. Post reorganization, will I be just one company or will I be multiple companies? While the NCLT was doing this, there was also a working group set up by IBBI, which discussed what a group insolvency framework legislatively could look like. Broadly, the approach of the working group was as follows. It said that we should try first to implement a procedural coordination framework, and this had different levels of coordination. One, you could have communication between different IPs, different COCs, different courts. A higher level would be to actually have a single IP and a single adjudicating authority and a single application to file insolvency for any of the insolvent companies. And then a further higher level where you could actually have group coordination proceedings. So the question that we were talking about, that how would you valuize the assets of those companies where multiple companies actually operate together in say, for example, a value chain. You could now propose a common resolution plan. What the working group also recommended was that all of this really needs to be done largely at the discretion of the stakeholders. So apart from information sharing, which it said should be done mandatorily, how you would do everything else, when you would do everything else, whether you would do any of these other forms of coordination would really be left to the stakeholders, which is then a flexible regime, which I think to an extent really takes away from the problems that dissenters to the group insolvency regime talk about. And finally, what it said was that while substantive consolidation is not something that they want to roll out right now, they do think it's something that can be rolled out in the later stages, but it laid down a very strict test to actually have something substantively consolidated, which is that you have to absolutely show that the assets and liabilities are so intermingled that it won't be possible to separate them. Now, in something like a Videocon, I do think it's arguable to say that it is possible to separate the liabilities of the company and keep the assets together in the form of, say, a common resolution plan. And in that sense, I think it's important for this particular group insolvency framework that was proposed by this IBBI working group to be deliberated upon and to possibly see the light of the day as law, because it offers a very flexible and useful sort of solution to the problems we're facing in group insolvency.
Thank you so much, Shreya. A comment from Mr. Khare.
Thanks, Shreya. I'll add, before we get into the Indian context, I think it's also useful to look at how group insolvencies are tackled in other jurisdictions. And I mean, the US in that sense is a very good guide in terms of how the laws evolved over there. Now, I think one of the things that a court in such a situation, or forget a court, one of the things in such a situation that needs to be balanced is the equities of consolidation versus the equities of not consolidation. So inevitably in any sort of group scenario, and Shreya did a very good job of sort of pointing out how that would come about, you will have aspects that are intermingle to an extent that it's impossible to have good resolution without separating them. And you will have aspects that are sort of kind of separated. And typically you see this in lending patterns to large groups as well. So often, you'll have sort of loans to maybe the main sort of holding company whose business depends on what the subsidiaries are doing. You may have special SPV loans where one particular SPV sort of secured separately, and the loan is made to that entity's business by itself. So I think that's sort of one of the main questions as to whether one should consolidate or should not consolidate. And essentially, that's the role the court plays, which is in sort of balancing those equities. Now, I think actually the Videocon NCLT judgment did a very good job in this regard. They sort of, set out, they established two principles, which is that there are two types of commingling. One is asset commingling, and the other is debt commingling. So you could have a situation where the business itself is so interdependent amongst various group companies that you can't really have a resolution of one without having a resolution of the other, as opposed to a situation where the businesses can run separately, but you do have cross liabilities, co-obligors, guarantors, etc. And I think in that judgment they sort of said that where the assets are commingled to such a degree, they ordered consolidation, where factually they found that companies had independent businesses, or they were satisfied that independent businesses, they didn't consolidate those companies to the extent, even if they sort of had commingled debts. Now, so I think in terms of actually addressing it to the law, now I know the IBC in general in a lot of cases seeks to be a prescriptive legislation, i.e. trying to lay down the principles in the law itself without leaving too much room for a lot of arguments in court. But I think this is one of the situations where it may be best to sort of empower the courts to make a particular decision given the equities of a particular case, maybe set out the principles within the law itself. Procedurally, of course, there's a lot we can do to aid the sort of consolidation. Of course, one of the main practical problems you have is that all these the companies who you might otherwise want to consolidate will go into IBC at different times, and your clock starts ticking from the first one. So that's just an example of where procedurally you could possibly set the clock back to where maybe the last company that came in. Just as an example.
Thank you. Are there any comments or questions from any audience members on the subject of corporate groups? Yes, please.
Thank you. The question on group insolvency starts with the question of default. Now, it's presumed that default in one company will be default in other companies, purely because either they are connected by a value chain or because they are connected by common management. It may not be likely. In the examples that was pointed out, it was obvious that they were connected in many ways. But in most cases, it may not be established in that sense. So, I don't know, whether because the stakeholders are different, the shareholders are different, the companies are run differently. Even in a value chain, it's likely that the company can, if it is small enough, to shift gear and provide services to allied sort of companies and so on and so forth. So the presumption that one default is a group default is something that needs to be thought of and discussed. The second is in terms of what you call demand and supply. Many times we find that the demand for asset in one particular company is much higher if you go alone rather than going as a group, right? And I think in the example that she has pointed out, it's likely that one asset would fetch more suitors than if you say that you have to take the group. So in that sense as well, from the perspective of what sort of demand is created by the market, to put a one-size-fits-all sort of scenario may not be value accretive in some way. So it needs to test the markets in some way, and that is probably the option is to try and give them a group asset or bid separately for assets in some way or the other. So these are a couple of comments that I thought.
Thank you. I think they're both very important points on the presumption of group insolvency. I mean, what you say is plainly right, and I think the kind of mechanisms Shreya was describing can only sensibly be applied to those members of the group that are distressed. And then as to the second point about maximising value, I think that's also right, but it raises the trade-off that Shreya anticipated earlier, because you may get a higher value with substantive consolidation ex post, but the question is what implications that has ex ante, given that creditors have to adjust their expectations to the assets and liabilities of the group rather than the particular subsidiary they might have wanted to deal with. There was a question, I think, from Nihil.
Just a comment similar to your point. I mean, I think you can't look at the question of group insolvency without looking at the general company law construct. I mean, it's a US concept to have groups, but then the corporate veil is very easily pierced in comparison to English law. So the two go together. I actually don't think Videocon's a good judgment at all. It's a case of the court going beyond what the law actually says. So if you have that, and obviously there is a problem, then you have to consider what the whole individual company versus enterprise concept as a general matter of company law as well. I think the two have to go together.
Thank you. There was, yes, of course, Mr. Sinha.
So I think just to the point, I think one of the things therefore to keep in mind is that perhaps the law should have an enabling provision, but it should not be made prescriptive whereby the NCLTs and others mandate that you have to get into a group level of insolvency. It has to be then left to the wisdom of the committee of creditors of the various companies to decide that, to the points Shreya making, whether it is going to be best for a value maximization to do it individually, is it best to do it together, and therefore the law should just provide an enabling provision for us to do it. Today the law doesn't have that enabling provision, so rather than prescribe and say this is the way it shall be, it would be one of the ways to think about it.
Thank you, Mr. Sinha. Now, I know there are two other questions. There was one from that side and then the gentleman there, and then we should definitely talk about personal guarantees. There was also a question over that side. That was first. A woman about 4 rows back, I think. Yeah, thank you.
Can you hear me? I don't know what since you can't. Yeah, so it's both a question and a comment. I think one of the biggest concerns with group insolvency law and policy is the whole idea of recovery versus resolution. And if you look at group insolvency regimes or the concept of group insolvencies, in my view at least, it is more recovery focused as opposed to resolution. And India, with tribunals such as the DRTs, which have not really been effective and efficient vis-a-vis time and the transaction costs involved, I think from today as we stand, we really do not have the infrastructure to actually implement a law that will support group insolvency regimes from a resolution standpoint. So it's just comment with respect to statistic and law as we stand right now, and I would really like the panel to either disagree, agree, or maybe offer an insight into what they think should be a policy other than an enabling provision, because I think that would open up another brand of litigation that I don't know if we have the time for, really. Thank you.
Thank you. Are there any panelists who would like to respond on the specific question of whether there is the infrastructure in place to support the kind of reforms that Shreya mentioned?
So this was something that the working group did discuss as well. So you're entirely right that with a group insolvency regime, there might be certain kind of infrastructure which you need, and we know that our infrastructure is quite clogged. But I think the beauty of what was proposed by the working group was that it relied very heavily on stakeholders. So it didn't really require you to constantly go for orders to NCLTs, etc. And because it left it so much to the discretion of stakeholders, and because it was a procedural coordination mechanism that was proposed and not a substantive consolidation one, so the rights and liabilities were just not touched. All that was touched was how you're going about carrying out your resolution exercise, how you're going to market your assets, etc. There was an expectation that it won't increase the amount of litigation. That said, I think your general concern that we need to, if a group insolvency regime is implemented, you will have to supplement NCLTs in terms of training, in terms of capacity, IPs, etc. All of that is valid. It's just that I do think that this has been taken into account while proposing that framework.
Thank you, Shreya. There are two more questions. Are we finishing at 4:15, or is there a break between 4:15 and 4:30? That you would like us to go to the next topic? Yes. Devanshu is telling me to do my job as chair. Therefore, I must ask for the other two questions to be held until the break. Is that okay? I'm sorry, but I must be strict now. We must go on to personal guarantees. I apologise that we can't take those questions. So now we're going to have an initial presentation of thoughts by Dr. Mukulita, followed by a brief response from Mr. Sinha, and then any questions and comments from you again.
Thank you. Personal guarantors is a part of the component of the debt transaction. We find that under the code we have only two provisions. Section 60, which talks of making of the application for insolvency of the personal guarantor and transfer of the application if filed in the DRT or some other code to the NCLT. If that personal guarantor is to the corporate debtor, because both the procedures it saves judicial time and it saves all those issues also to be considered together by considering both the applications together by the NCLT. This personal guarantor concept is not new. It is since ancient times, and it's a matter of trust that when you advance a loan, then the one requires a guarantee. And this provision of the guarantee is provided under section 126 of the Law of Contract, Indian Contract 1872, enacted on 25th April 1872. And in this, section 126 talks of the guarantee, contract of guarantee, and it involves a tripartite agreement, debtor, creditor, and the guarantor. The law of contract talks about the discharge of the guarantee, continuation of the guarantee. As far as the corporate businesses are concerned, I feel that whatever guarantee is given initially, it continues for other transactions also, and there is a continuing guarantee. Now under the code, we find that recently, just to inform you, everybody is aware of that, the government has notified the rules regarding personal guarantors, as well as the board has also notified regulations regarding insolvency resolution personal guarantors and the bankruptcy of the personal guarantors. Now this question was also considered under the SR case also, but the Supreme Court has, I quote about the Supreme Court's observation. Section 31(1) of the code makes it clear that once a resolution plan is approved by the committee of creditors, it shall be binding on all the stakeholders, including guarantors. This is for the reason that this provision ensures that the successful resolution applicant starts running business of the corporate debtor on a fresh slate, as it were. Here, Apex Court did not deliberate upon the issue whether the guarantor to a corporate debtor will be liable towards the principal debt or the extent of the remaining liability. I think during the process, I find that when the process starts, there is a committee of creditors where we find that the committee of creditors consists of financial creditors. However, the members of the suspended board of directors are given notice of the committee's meetings, and they are there in the meetings also, but not the personal guarantor. The liability of the debtor is shifted by the concept of subrogation to the guarantor, but whether notice is given to him when the CRP starts is a question. Whether notice needs to be given to the guarantor also. Whether notice of the committee of the creditors, meeting of the committee of creditors needs to be given to the guarantor there is no express provision into the code, nor I think the regulation is required for that purpose also. Secondly, the guarantor is bound by the terms of the resolution plan. The extent of its liability will also be affected by the resolution plan. As the amount paid to the resolution applicant against the principal debt on behalf of the CD. The guarantor being bound by the terms of the resolution plan, no insolvency can be initiated against the guarantor unless the liability is crystallized through resolution plan. So when should the proceeding should be initiated against guarantor, at what point of time and for what amount, I think that needs to be clarified. Maybe in times to come, judiciary may clarify this. The other issues which relate to the guarantors, regarding the behavioral changes we expect, because as far as the CRP process is concerned, we have noticed and the behavioral change is visible. I think number of cases have been withdrawn, resolved, liquidated. So these changes are visible. But after this personal guarantors rules have have been notified, and the personal guarantors will be proceeded against, or maybe personal guarantors may take the seat of the creditor. It may be in times to come, the personal guarantor may himself file an application for insolvency resolution of the corporate debtor. And what should be the process, whether he will be entitled or not. Secondly, if he has paid off the debt, then he becomes the creditor. So what will be the share in the distribution of assets after liquidation or in the resolution process? That also needs to be, I think, clarified or needs to be explicitly mentioned in the code. And if he has share in the liability, then his assets will be in stress. So stress of the company transfers to the assets of the guarantor. I think extension of the stress to the guarantor. So I think these are certain issues. I think in times to come, when the new cases regarding guarantors will be filed or by or against, so those issues will be settled. Now as far as the guarantor is concerned, my point is that the guarantor's liability is coextensive. So naturally, the liability of the debtor, when it shifts to the guarantor and in the resolution plan, whether liability will be limited or will be coextensive for the whole plan or process, that needs to be seen. Maybe in times to come, we have to have separate provisions, special provisions for personal guarantors, because at present, we have devised or we have issued the regulations and rules based on the process of the CIRP, but regarding liability, otherwise, maybe in times to come, personal guarantors will be reluctant to give guarantee if they are at loss or they are adversely affected. Thank you. Thank you.
Thank you so much, Dr. Mukulita. Response from Mr. Sinha.
So, as I said to you before we started, I have a lot of responses, but I'll limit it in the interest of time. First and foremost is, I think, the law needs to get settled here with respect to double dip. What we are now faced with is a strange situation where the NCLT, the appellate body, has held that if you have filed a CIRP against a corporate debtor, you are prevented from filing a CIRP against a corporate guarantor. If that principle is to be applied insofar as personal guarantees are concerned, this whole provision is going to be useless till that law gets settled. So we have to first settle, because and if you look at it today, at least fortunately for banks, the other tribunal we have, the debt recovery tribunal, has not taken a similar view, which means that for recovery of our for enforcement of our security, the personal guarantors are concerned, we are getting reliefs from the debt recovery tribunal. So that is a fundamental issue that needs to get settled. The second, I think, larger concern is, which perhaps will have to get sorted over time, is whether or not the insolvency professionals are equipped and trained for the very, very large powers and duties which are cast upon them, because here their role is now changing not from just mere filing and going to the NCLT for everything or a decision. Here you're looking at the IP who needs to take a decision and a view, needs to be an advisor, a debt advisor, with the personal guarantor, and therefore make recommendations with respect to whether or not the resolution plan, the plan, etc., is worth considering. So I think, and I'm not sure whether, with due respect to all the insolvency professionals, that whether that kind of expertise exists in our market. So that's, I think, the second area which we need to deliberate on and think, at least build capacity and around that. The third, I think, important aspect is, as someone mentioned, that look, there could be these filings made by both the guarantors and then as well as the creditors, and the area, sometimes it has the risk of the moratorium being misused, because from the time you file, you have an interim moratorium, and then it goes right up to the time the person is declared bankrupt, and all it does is that it then becomes the person is declared bankrupt, and essentially, if he or she does not have enough other companies or has effectively moved his business into family and friends, it really not going to affect his life. So how do you sort of deal with that concern? And I think as I said, I have many, but I'll just stop at the last one, is with respect to the fact that you have the debt recovery tribunals, who in certain scenarios are the tribunals who are going to be tasked with dealing with this. There have been continued concern with respect to the time it takes for these for our regular debt recovery tribunal matters to get sorted. They have their main job of the recovery. Then we have the SARFACI Act. They are an appellate body there. Now you're burdening them further with another set of tasks and duties. Whether our infrastructure of the debt recovery tribunal is equipped to deal with this pressure. I think these are my top issues, and as I said, I have more.
Thank you so much, Mr. Sinha. Now, before we take any comments or suggestions from the audience, I'd like to ask Aishwarya to respond as well, especially because I think our chances of dealing with the cross-border topic in this panel are very slim indeed. So, Aishwarya, your comments first, please. No, don't be quick, please.
So, I think it was rightly pointed out that, first of all, I think before we approach even how this is going to be implemented, but for this to actually be fruitful, especially just in relation to personal guarantors, the issue of common claims or double dipping and the issue of subrogation are like two issues which we may really want clarity on. Otherwise, this is just something that is going to be stopped either because of a moratorium in a CIRP proceeding, or it won't actually function as a personal guarantor mechanism but just an individual going through. That is one. Two, and I think that this is an issue that maybe will develop in practice, but I think it will be tough to incentivize insolvency professionals to actually take up these cases, at least in big numbers. One is because a lot of these cases will be low value cases, even though when we think of personal guarantors, we think of really sophisticated individuals who are promoters of companies, but in India you do require guarantees for a lot more loans than you would in a lot of other places, which means that there is a huge bunch of personal guarantors in the market, a lot of whom may not be sophisticated enough to, or may not have enough resources left when they're brought to insolvency. So that is another issue on taking up of cases by insolvency professionals, which is why there's also maybe a need to have a rule for what happens in no income, no asset cases, because right now there isn't anything that sort of prescribes or creates certainty on what happens if an IP can't get his or her fee. The third issue I'd like to point out, and I think that this was touched upon, was also the sophistication of IPs or debtors for coming up with a repayment plan completely themselves. Remembering that at this point, there may not be enough money to actually get a lot of counsel, right? There will be a limitation, at least in some cases. But we do see interesting examples from other countries and how they deal with it. For example, there are templated repayment plans in some countries, like UK has a very something that came up from the market, where a lot of creditors came together with regulatory bodies, tried to come up with a sample IBA, which is a parallel to an insolvency resolution plan, insolvency resolution process, and came up with the repayment plan that could actually be utilized and is actually utilized in many cases, which reduces a lot of the burden. Yeah, these are the quick points.
Thank you so much, Aishwarya. Are there any comments from audience members? Yes, there's a gentleman down the back. Thank you.
My question is for academic interest. If you remember Enron fiasco, if the two corporates form a partnership firm, okay, which is allowed, if the partnership firm goes bust, then what are the can these two corporates for the partner in their partnership firm come under this IBC?
The question, I think, is if two people come together in a partnership and there are personal guarantees.
Corporates.
Two corporates come together in a partnership and there is a personal guarantee and there is a default, does this regime apply? Yes, exactly. Is there someone who'd like to?
If two corporates are forming partnership firm and there is a CRP process, you meant to say?
If you go back to the Enron case, same thing has happened.
I'm not able to.
See, in Enron, a long time back, there was an Enron case, and that company has formed a partnership by the partner in a particular partnership firm, okay?
Yeah.
And the partnership firm had huge liabilities, which was not even shown in the balance sheet, okay? And the entire this corporate, went down. My question is that under IBC, if two corporate entities in India, they are forming partnership firm, and that partnership firms come under huge liabilities, can the IBC be invoked for these corporates or not? This is my question.
IBC Part 2 deals with the insolvency of the corporates. It deals with the insolvency of the corporates. Certainly the IBC can deal with it. This Part 2 will apply to the corporates. I am unable to understand if the entity is corporate.
Yes.
So certainly the Part 2 of the code will apply.
See, partnership firm, there is a A-B partnership firm, with both the partners are the corporate entities. Okay. So now the partnership firm creates huge liabilities, unable to meet those liabilities, and as per the partnership act, these corporate partners, they are liable to make the losses of that partnership firm. Now, whether this insolvency bankruptcy law will go down to these corporates or not, this is my exact question.
So I guess what you're talking about are more of, when you're talking about partnership, you're talking about individual insolvency.
I think you have asked a very good extra question.
So if it's a partnership firm,
I think it should come under part 3.
So as far as I understand,
I can see that this is a very good question. I think it's the question of the day, and that we cannot resolve this question in the 1 minute we have remaining. But thank you for the question. Sorry, there's a gentleman who would like to speak to
I think
this.
this should come under part 3.
Hold on, wait for the microphone, please. Yeah.
I think it should come under part 3 of the IBC. Even if corporates are the partners in the partnership firm, but this is the partnership firm which is having the losses. So it should come under part 3.
So as far as I understand, if it falls within the Indian Partnership Act definition of a partnership firm, then it will come within part 3. However, if there are any other agreements by which you make any other sort of business relations between corporates which are not covered by a partnership firm, unlimited liability, etc. definition, then it would not come within part 3.
So, no, so I think one thing in such a case, what you would have to establish is the direct liability against that corporate partner in his individual capacity. Now, once you have established that, whether you are looking at it because the partnership itself has dissolved and the liabilities have attached individually, whether they have at the time of taking the loan provided any guarantee themselves for the loan of the partnership. In those circumstances, once you have the liability, once you can clearly establish that the debt is payable by that corporate entity, which is the partner, in his individual capacity, then you can just go under normal Part 1 of IBC.
I think what is helpful as well, in this discussion, apart from the substantive point, is also there's been a theme, I think, in the discussion on personal guarantees about the complexity of the interrelationships between these rules and other regimes. And it seems to me there's still quite a lot of work to do to work out how this fits with the general regimes that apply outside of the code. Now, Devanshu has come to me and said we have 5 minutes and that he does not want us to leave without... I know there's a question at the back. Does this relate to personal guarantees? Because I think...
It does.
Well...
A quick one.
It has to be very quick because I want to give the final word to... Yes, go ahead.
So I'll probably cut short to one query. I had one with Mr. Sinha as well, but main is on the personal guarantee. So are we very clear on the jurisdiction, because I feel that the jurisdiction for the personal guarantors to the corporator would lie with DRT. In case the corporator for which he is a personal guarantor, in that case it will lie with NCLT. Now the concern is when he initiates on his own, he goes to DRT, yes. But halfway through the corporator goes to NCLT. And then we are saying that over the period, probably the files will have to change and the entire proceeding probably either will get restarted. So are we kind of really mindful of this entire transition? Because on one side we heard DRT is overburdened and all. And then we're expecting someone to kind of do a half kind of thing. And then a half-baked solution goes to a different jurisdiction. So we are just trying to kind of see, have we really thought about it, or something needs to be done now when we are really about getting started on this thing. Thank you.
Thank you for that. And that comment received more nods than the previous comment, so it's a good point to pause on the discussion of personal guarantees. Now, Devanshu has asked that we not leave without mentioning... No, he says now 3 minutes. Our 5 minutes is 3. Aishwarya was going to make some comments on cross-border cases, so what I will ask her, and she has no notice of this, is if she could please give us just her wish list. What are the 3 or 4 things, perhaps, that would be the most useful things for regulators and rule makers to focus on to improve the position in relation to cross-border cases? And we'll finish with those comments. Thank you, Aishwarya.
Thank you. So very quickly, I think a few things to think about is a lot of times cross-border cooperation happens without there being a law for it. We see this in India too. We see that in cases like Jet, for example, we are noticing that cross-border elements come up and some form of cooperation does end up happening, which brings us to why do we need a cross-border law anyway then? If courts anyway do manage to do this, then why have a law? However, one big issue that comes in is one certainty on how much can you take for granted that courts will help you with cross-border cases, especially for maybe foreign investors or foreign companies. To understand that there is some sort of certainty in the market may also, one, build more trust in the market, 2, boost investments, and 3, create more consistency between what different NCLTs or what different courts would do under cross-border cooperation. Second is that there are multiple elements which may still be missing if you just leave it to courts to actually just come up with cross-border cooperation mechanisms. There may be recognition-based remedies that courts may not have legal sanctity to actually order without there being some sort of thought about it in the law, or some sort of enabling provision in the law. However, and this is what I'd like to caveat it with, to say that these things are important is true. However, there is a huge concern in terms of infrastructure, and we, I think, came upon this topic in terms of our discussion on group insolvencies too, in the way that all these second generation reforms seem to have a lot of discretion which will be included because of the nature of the law that it is, because the scenarios will be differing in most cases. The amount of in group insolvency, either consolidation or interrelation, or in cross-border, the kind of assets or liabilities that are placed in different places will be so distinct in each case that it's really tough to be prescriptive. Yeah, but that's what I would add, that yes, a law is important, But I think what goes beyond the law is that is extremely crucial here is judicial sophistication and more resources with the judiciary to actually be able to do this well.
Thank you so much, Aishwarya, and I'm sorry that we didn't have time to have a proper discussion on cross-border insolvency. I think it's the last time Devanshu will ask me to chair a panel, so I obviously can't keep time. But thank you very much to the panelists and to the audience members for fantastic contributions. And can I please abuse my position as chair once more by congratulating the IBBI and Vidhi on what has been an absolutely fantastic event. I have learned a huge amount today, so thank you very much.